for capital
Counsel,
cases.
you talk about opening the floodgates, but you're the one who's proposing a theory that no circuit has ever accepted. Yours is even more limited than the Fifth Circuit. You're saying only IAC as it relates to a knowingly or not knowingly enter a plea is cognizable. The statutory maximum, you're saying, is not cognizable either unless the plea agreement tells you that the judge will sentence within the statutory maximum. Because the logic of your argument is, if I agree, if I say in the plea agreement the judge can sentence you any way he wants, that would not be cognizable, correct?
So our position, yes, is that if in the plea agreement you expressly say, I am waiving my right to appeal on the grounds that the statute...
Every other circuit has something broader than the Fifth Circuit. Virtually all of them have something for constitutional errors of the nature that Justice Gorsuch was talking about, either under a miscarriage of justice rubric or under a plain error or unconstitutional violation. So this is not floodgates that are opening. Whatever is being appealed now is pretty narrow. It's a small fraction of the plea agreements are being appealed, and those that are, there's an even smaller fraction where there's any time being spent on them. So waving a flag talking about floodgates opening seems rather exaggerated by the government.
So the burden that we experience in the circuits right now really depends on the way that this exception is described in the circuits. In the circuits that have open-ended exceptions for, all constitutional claims, the U.S. Attorney's offices do report that to be a significant burden, because it's quite easy to characterize even garden variety claims as a due process violation, as I think this case illustrates. In circuits that more carefully circumscribe their exceptions to 2 or 3 discrete situations, it is admittedly less of a burden, but the problem is that whether we get the benefit of our bargain, which was to not have to litigate an appeal, just turns entirely on the defendant's choice, because if the defendant chooses to raise a miscarriage of justice exception...
If you're not happy with the bargain, do what you're threatening to do, which is go ahead and prosecute them.
But again, our whole purpose of entering into the appeal waiver is that we wanted finality, and we didn't want to have to keep litigating.
But the problem with finality is that you're basing it on the good faith of a third actor, meaning you're depending on a district court judge to not, or they are a district court judge to follow their constitutional and statutory obligations. I would think it's unenforceable to enter a contract that says you are going to be sentenced by a judge who does not have to follow the law.
That is very much not what an appeal waiver says.
Well,
an appeal waiver
that's
says
exactly what you're saying.
Not at all, Your Honor.
That's exactly what you're saying, which is if the judge uses impermissible race factors, impermissible sex factors, religious factors, that can be waived. That's saying that a judge, you're entering a contract that says if your judge is biased, if he doesn't follow the Constitution, if he makes plain error judgments that are clear and undisputed, there's no remedy for you.
So again, an appeal waiver is not saying you can be sentenced however you want by a judge. The judge is oath-bound. The judge has to follow the law all the time. The appeal waiver is just saying the final decision maker is the district court. And by the way, that was the system that existed for 100 years in this country. We didn't have sentencing.
Sorry. Just out of curiosity, what's your backline position?
Sure. So we think that if this court is going to go the miscarriage of justice route, again, we don't really see a basis for that in contract law, but if you're going to go that route, our strong preference is that you follow the circuits that have, basically done what the Fifth Circuit has done, but just with 1 or 2 more exceptions that seem to capture some of the concerns that people have here. So we like, for example, the 7th Circuit's test. I would put a little bit of a gloss on it for precision, but what I would say are the 3 circumstances that would be qualifying as a miscarriage of justice would be a sentence that's explicitly based on a constitutionally impermissible factor like race. 2, a sentence or condition that is categorically unlawful for the statutory offense of conviction, and 3, a sentence reached without even a minimum of civilized procedure. That's the example of, the orangutan
Why would it